Last week, our next guest, Neil Katyal, gave a masterclass in how to present a case before the United States Supreme Court in an argument over the meaning of this clause of the Constitution. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may, at any time, by law, make or alter such regulations, except as to the places of choosing senators. The North Carolina legislature appealed to the Supreme Court, arguing that the United States Constitution gives the North Carolina legislature complete power over elections, and the Supreme Court of North Carolina cannot be allowed to rule on any election choices by the state legislature. Here are Neil Katyal's first words to the United States Supreme Court.
For 233 years, states have not read the Elections Clause the way you just heard. There are two reasons to affirm. One is that when enacting legislation, there's no such thing as an independent state legislature. The other is that North Carolina statutes authorize what the North Carolina court did. I'll focus on the first. Petitioners' idea that state legislatures created by state constitutions are independent of them is wrong. It is rejected by the Articles of Confederation, rejected by the early state constitutions, rejected by the founding practice, especially in New York, where judges vetoed federal election bills. It's also rejected by this court in cases such as Smiley and Hildebrand.
Joining us now is Neil Katyal, former acting U.S. Solicitor General and an MSNBC legal analyst. Neil, thank you very much for joining us tonight. This is the fanboy version of me, because this feels like talking to Sinatra after a big concert. This was, you had me on the edge of my seat, especially at that beginning, because there was none of the kind of little bit of throat clearing that sometimes occurs with counsel as they kind of get themselves started. You just came out like a rocket and kept going with that energy and pace all the way through, every minute that they gave you. And I just want to quote, so it's not just me, okay? Michael Luttig, your Republican co-counsel, as distinguished a practitioner, former federal judge as you could ask to be in that room with, he was in the room. He said, single best oral argument I have ever heard made before the Supreme Court. He was masterful. And so, for the audience, the key points that you were making and the urgency with which you were making them in that limited time you had with the court, what did it feel like to have that burden, in effect, of standing up there arguing in favor of American democracy?
Well, first of all, Lawrence, I'm no Sinatra, and the really
Sinatra of the Supreme Court. That's your new review.
But there's actually a serious point here. I mean, I really appreciate the kind words, but the truth is, I was working with the best team ever assembled, and those words were often not my words. They were the words forged and ideas forged after 8 separate moot court practice sessions and the like. But the basic principle that we were trying to get at is that the American government from the founding on has always been about checks and balances. And part of that checks and balances has always been state courts reining in state legislatures. Like what happened in North Carolina, it's a pretty evenly divided state politically, but the legislature gerrymandered it so there'd be 10 Republican seats and 4 Democratic seats. And, the same thing has happened in the reverse in other states. So I don't think it's just a partisan issue or something like that. But if you think back to like the 2020 election and those 62 courts that ruled against Donald Trump, many of them were state courts. And this theory, which is being floated by a bunch of Republicans, is that these state courts are now cut out of the process altogether. And maybe that's like the way like the Soviet system works, but it ain't the American system.
And one of the things I noticed was that whenever a justice would ask a question that might sound counter to the point you were making, you always had a way of making it sound like you were in agreement, or you would find a way to show that justice his own history with this subject that would pull him closer to what you were thinking. It was just, for legal practitioners and law students, that part of it is just so brilliantly executed in your argument.
Well, thank you. I mean, our job as Supreme Court advocates, there are 9 of them, and it's like 9 separate courts in a way, with 9 separate books of precedent. And so our job is to really try and speak to each of them in the way that their methodology. And so, like, for example, the very first question was by Justice Thomas, and he really is someone who thinks about history. And on this one, history was all on our side. And so I basically said that to him. I said, look, I've been waiting for a case like this for 2 decades of practicing before you, because this is one that speaks to your method, Justice Thomas. And you try and do that with every one of them, because, at the end of this, Lawrence, and I may, be a little bit different than some of your viewers, but I do believe in this concept called law. I do think there's something there. I'm old-fashioned about that. And it is such a privilege when you get to be part of it and standing in the Supreme Court of the United States. And of course, obviously here, standing up for democracy and why my parents came to this country. There's no greater privilege one could have as a lawyer.